Want honesty? Most violent crimes aren't complicated. They're impulsive, sloppy, and tragic. I've spent 40 years proving that. I've watched lives end, families shattered, and futures evaporate, all because someone thought violence was a solution. It never is. In my humble opinion, arguments to keep out evidence are frequently denied. And even if a judge did rule in Luigi's favor, we're talking about the ghost gun that was in his possession, the manifesto that Luigi allegedly wrote. Other evidence abounds. On top of that, if there is some type of other evidence that's unpublished, that too still comes in. I can guarantee that this case does not get dismissed just like that. The cops are not obligated to explain anything to him, and they search the bag as part of the arrest process, as part of securing his property. They don't need a warrant for that. I believe suppression might succeed partially, but not enough to derail the entire case. They expect key items, like the gun and the notebook, to remain in. There is serious concern, however, about how the medical records were obtained. The defense used strong language like fraudulent subpoena and suggest a possible HIPAA or privilege violation. Prosecutors are pushing back hard, claiming that they acted lawfully and that any overproduction by Aetna was an honest error, not intentional misconduct. I think a full suppression is highly unlikely. Maybe some specific pieces, like the medical records or privileged documents, could face some real risk. More likely than not, the bulk of the physical evidence, backpack contents, weapons, notes, and the fake name statement will remain admissible. Prosecutors marshaled multiple independent legal grounds for the same search and/or evidence. Where a prosecution shows alternative exceptions, such as search incident to arrest, inventory search, community caretaking, exigent circumstances, courts commonly decline to suppress. The existence of multiple doctrines makes exclusions less likely. And as you can see, the November 21st prosecutor's omnibus response very explicitly lists those alternatives. In my 40 years experience, courts routinely admit basic identity statements and lies about identity. Case law treats a suspect's false name as non-testimonial or as a routine booking information, so Miranda-type suppression usually will not apply. The doctrinal baseline makes the Mark Rosario statement almost impossible to exclude. Procedural and/or technical defects rarely sink an indictment by themselves, unless there's clear prejudicial misconduct. Defense arguments about typos, formatting, or ministerial errors are often rejected unless a defense proves a substantial constitutional or statutory violation. Prosecutors flag Supreme Court and other controlling precedent to counter those claims. However, there are a few higher-risk trouble spots where suppression or adverse rulings are plausible. For example, improper subpoenas or allegedly fabricated dates for medical records. If the defense proves an unlawful procurement, in this case, HIPAA matters, or any subpoena abuses or fabricated court dates or material misrepresentations, a judge could exclude certain documents or sanction prosecutors. Coverage and defense filings raise this as a live issue. Let me show you realistic odds based on the legal filings. What would increase the defense's chances of suppression, you may ask? The answer is, if the defense has concrete proof such as email, chain of custody gaps, contradictory sworn statements, that police or prosecutors intentionally misrepresented facts or fabricated filings, and if the defense actually has independent witnesses or documents showing subpoena abuse or forged dates. What would keep the evidence in, you may ask? The answer is judicial deference to multiple legal exceptions for searches, established precedent admitting identity lies, and booking statements. Prosecutors' thorough-based precedent-backed response in their 120-page brief that addresses each of the defense's claim point by point. 11 months went by. Yikes! Seriously, how do we even get here? When you strip away all the legal jargon, here's what's really happening with the Altoona search. Police say they made a lawful arrest. They claim they had probable cause because they believed Mangione was using a fake ID. Under both Pennsylvania and federal law, once cops arrest you, they're allowed to search you. and anything you're carrying without a warrant. Under Pennsylvania and federal law, once police make a real lawful arrest, they're allowed to search you and anything you're carrying, like your pockets or your backpack, without a warrant. That rule is meant for officer safety and to stop evidence from being destroyed. It's a basic rule meant to protect officer safety and prevent people from destroying evidence. Prosecutors say that's exactly what happened. He was arrested, they searched him, they searched the backpack as part of the arrest. If the judge agrees the arrest itself was valid, that rule alone makes the search legal. But prosecutors did not just stop there. They also say once they took his belongings into police custody, Altoona PD followed their standard process and did an inventory of his property at the station. That kind of inventory search is allowed as long as the police follow their usual procedures and are not using it as a fake excuse to dig for evidence. According to the filings, that's what happened. The items were inventoried, documented, and then police went and asked a judge for a warrant right afterwards so they could keep the property longer and hand it off to NYPD. Judges like this kind of sequence because it looks routine. Arrest, inventory, then a prompt warrant. On top of that, prosecutors bring up safety concerns as another backup justification. Pennsylvania recognizes that if officers believe there's an immediate risk, like a weapon, danger to people, or evidence that could disappear, they can act quickly without waiting for a judge. Prosecutors point to what they say was inside the backpack, including an alleged ghost gun, and writings to argue that officer safety and urgency would have justified the search, even if the other rules somehow didn't apply. It's an extra layer of protection for the prosecution. And then there's the follow-up warrant. Even when the police start with a limited exception like search, incident to arrest, or an inventory, getting a full judge-approved warrant soon after usually shores up everything. A valid warrant lets them keep the property, search it further, and deal with any long-term handling. Prosecutors say Altoona officers immediately assembled a warrant application and got it signed, specifically authorizing the long-term seizure and the transfer of the items to the NYPD. When a warrant is supported by probable cause and clearly establishes the items, courts are generally reluctant to throw anything out on a technicality. All of these overlapping doctrines matter because a court does not have to choose only one. Even if one of these legal bases works, the arrest, search, the inventory, the safety concerns, or the follow-up warrant, the evidence stays in. For the defense to win suppression, they have to convince the judge that every single one of these justifications was invalid and that the warrant itself was tainted by something illegal that happened earlier. That's an extremely tough burden. The weak spots the defense is attacking are mainly about how the whole encounter began. They're arguing he was cornered without reasonable suspicion, which means they're trying to show there was no lawful detention or arrest at all. If a judge buys that, then the search incident to arrest collapses. They're also questioning whether the inventory was really routine or if the Altoona PD broke their own policy, which could make the inventory look like an evidence hunt instead of a neutral procedure. And they're challenging whether the follow-up warrant was supported by clean, lawfully obtained information, raising issues under the Leon good faith doctrine and the Franks case if the affidavit had errors or admissions. Prosecutors say they got the warrant immediately, which makes it harder for the defense to convince a judge it was tainted. The filings also rely on Pennsylvania's standard search and warrant rules, including the Rule 200 series, along with recent Pennsylvania cases about search incident to arrest, the Blair County complaint, and the prosecutor's omnibus answer specifically lay out the government's reliance on search incident to arrest, inventory, and the later warrant. Those are the exact documents a judge will use to evaluate what happened. And the bottom line is simple. The prosecution has multiple independent legal theories that all support the same outcome. A claim-based probable cause arrest, a station inventory, and an immediate warrant each give the government a separate path to justify keeping and searching the backpack. With all of these working together, suppression becomes very unlikely unless the defense can prove there was no real arrest, the inventory was a sham, or the warrant was fundamentally tainted. That's why the prosecutors sound so confident. The structure of the law and the sequence of events strongly favor them. A lot of people are obsessed with the backpack. Backpack, 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 backpack. But let me tell you something nobody wants to hear. Even if the backpack evaporated from existence, this prosecution still has enough firepower to level a city block. So let's stop pretending this whole case hinges on a zipper and a shoulder strap. We're diving into what actually decides suppression battles and what does not. At the end of the day, this trial is all about whether the evidence can survive the chaos. Because when the evidence speaks, the noise fades.